next session, session number 3, in which we have a lot of international experts who are joining us from North America. We're very privileged to have them join us. I will introduce them and then hand over to the moderator, Ellen Bass. First, let me just introduce our panelists. Meg Kinnear, who is the Secretary General of ICSID, the International Center for Settlement of International Disputes, and she is in that position also Vice President of the World Bank Group. Prior to joining ICSID, Meg worked as Senior Counsel from 2006 to 2009 and Director General of the Trade Law Bureau of Canada. She has frequently spoken and published with respect to international investment law and procedure, including as a co-author of Investment Disputes under NAFTA. She has worked on various editions of that. I don't know if Meg's online, if you can see her. Meg, if you can say hello, maybe that will bring you on. I don't know. No? Okay, let me move on to our next panelist. Honorable Judge Daniel Weinstein. Daniel, you are in the same position as I am because you carry a name which also carries connotations. I hope you have no relation with the other Weinstein who's been in the news, just as I have no relation with the Sharifs who are also in the news. Judge Weinstein is one of the nation's US's prominent mediators of complex civil disputes. He is a pioneer in the development of mediation and teaches and lectures fellow mediators and lawyers throughout the United States. Judge Weinstein is recognized as one of the premier mediators of complex, multi-party, high-stake cases, both in the US and abroad. He is the recipient of the 2014 International Advocate for Peace Award from the Cardozo Journal of Conflict Resolution. He also founded the Class Action Settlement Administration, CASA, and is a former California judge and founder of JAMS, which is the world's largest provider of mediation and arbitration services. Our next panelist who will be joining us is Howard Herman. Howard has worked as a mediator and as a developer of ADR programs since 1985. He currently mediates through JAMS in San Francisco, where he specializes in matters involving high emotion and complex power dynamics. For more than 23 years, he led the highly regarded ADR program for the U.S. District Courts of Northern District of California. He previously directed a California State Court ADR program and coordinated an early version of what is now the mediation program of the United States Court of Appeals for the Ninth Circuit. Howard Herman frequently teaches negotiation and mediation-related courses at the University of California, Hastings College of Law, where he also co-leads a seminar for international judges and lawyers, which is entitled Envisioning, Designing, and Implementing Court ADR. And our session will be moderated by Ellen Bass. She is an attorney, trained mediator, and executive director of the Weinstein International Foundation. In her role as executive director, she manages the foundation's daily operations and works with the foundation's board of directors and global networks of senior fellows to implement the foundation's strategic initiatives while defining and developing its procedure and programs. We're very privileged to have her moderate this session. She's a graduate of the University of California at Berkeley, magna cum laude, and recipient of a Fulbright scholarship to Berlin, Germany, where she studied philosophy and comparative literature at Freie Universität. So without much ado, let me hand over to Ellen as the moderator for this session, please. PTV. Ellen, we can't hear you yet. Just give us a second. Ellen, can you say something now? Let's see if we can hear you. No, we can't hear you. We're having technology problems. Just 1 second. Ellen, can you try to say something now?
Yes. Can you hear me now?
I can barely hear you. I think we need the sound to go up at our end because.
Okay, we're testing on the microphones. How is this?
Ellen, I think we're getting somewhere. Can you speak again?
How is this?
Good, good.
Are you? Is that better?
Good. Yep. Go ahead.
Very well. Thank you so much, everyone. I was just saying that it's such a great privilege to be here with you all, with these distinguished speakers for this amazing event that's been put on, and we are so thrilled to be able to be here. We also are thrilled to be able to connect with you despite the technological issues. It seems that we've overcome them. And this is the way that we live today, as you all know, to be able to connect as we are here in the United States. I am in San Francisco. I am at the JAM San Francisco Resolution Center. And Meg Kinnear is connecting from Washington, D.C., I assume. I don't know that my distinguished guests who are with me need too much of an introduction beyond that which has already been provided. Thank you so much. And I'm not sure that Meg will need much of a moderator, but in any case, I'm happy to pose whatever questions might be helpful. So we've taken some time. So Meg, please, why don't you begin and just, I'm not sure that everyone knows about your background, your role at ICSID and what ICSID does. So just start and give us a little bit of a history if you would, and then take on from there. Thank you so much.
Absolutely, and I'm going to try one more technological feat, which is to share a PowerPoint. So let us see if I'm up to that task. I first do want to say, though, that I am delighted to join all of you here. I am the Secretary General of ICSID, and as you'll hear as we go through this PowerPoint, ICSID is the world's premier institution to administer investor-state disputes. And this is very much bound up in government's initiatives to attract and protect foreign direct investment, and is a very key form of international ADR, mainly arbitration, but also increasingly conciliation, mediation, and fact-finding. So allow me, if you will, to try to share a PowerPoint. Apparently screen sharing has been disabled. Perhaps Nudrat will share from that end so that I don't take up too much more of your time. Why don't I start, and hopefully we will be able to get the PowerPoint at some point as we go along. So what I wanted to talk about was why we have investment agreements and why we have investor-state dispute settlement, then the role of ICSID in this field, and then to talk a little bit at the end about ideas for states in particular on dispute prevention and dispute management, which are a really important part of the whole endeavor. First of all, as you probably know, investor-state dispute settlement is a very particular kind of international dispute settlement where a foreign investor comes physically to a host state and invests in that host state. So they may be setting up a plant, some kind of a business, anything like that. And Under investor-state dispute settlement, the foreign investor gets a right to make a claim against the host state directly to enforce the rights it has under usually an international investment treaty, but sometimes an international foreign investment law or an international contract. And remember, this is always pursuant to consent. So you can never simply start a case because, for example, you're a member of ICSID. It must be because there is consent of both the investor and the host state, and that's usually found in the treaty or contract or the investment law. To understand why this is important, I think you have to think about what the situation was before you had investor-state dispute settlement. And there were a number of shortcomings. In terms of domestic law, originally investors had to simply go to the regular domestic courts. But the problem was they were trying to enforce an international remedy. And across the world, most domestic courts don't have jurisdiction to enforce an international remedy. Even when they did, there were other sorts of problems that served as hindrances to this kind of an action. In particular, things like immunity claims by the state. States would have either absolute or a limited immunity, but that could be a bar to access to some kind of remedial jurisdiction. There were in some places problems of local bias in courts. There were a number of locations where there were even no court systems or inefficient court systems. And there were a number of doctrines where in some states, particularly Latin America, courts would require you to go through every single step in the domestic court system before you could even think about trying to go to international remedies. So at the end of the day, that really provided little, if any, ability to get a resolution of a problem. On the international plane, when a foreign investor was trying to rely on their international rights, there were also very limited protections. The main one was what we call diplomatic protection, and that was essentially where you had to go to your home state and say, will you start an action about what happened to me against this host state that I'm in? And states are very often reluctant to do that because they have a whole host of interests with other states and they don't want to alienate other states. And that's especially the case, sadly, for small and medium-sized investors who really don't have a lot of ability to encourage a state to go out and sue on their behalf. There were a number of other problems with this diplomatic protection, including how vague customary international law is. And I think that's something we are still dealing with, have done so fairly well under treaties, but it is still an issue. Requirements to have continuous nationality, and the investor had to basically prove they had a strong case and give up all control over their case. There were a number of situations where there were things like claims commissions, but those were few and far between. And finally, in international remedies, we talk about gunboat diplomacy, and just saying the title, you understand why that is not a satisfactory dispute resolution tool. At the same time, you have increasing importance of cross-border investment, and that's especially after World War II and accelerating in the 50s and the 1960s, where you have a lot of new states who are emerging. And states are realizing that they cannot fund all of the things they need to. Government funding alone will not do that, and that they need to attract foreign direct investment and increase private sector investment. At the same time, governments all realize the benefits that come with this, things like infrastructure, technology transfer, creating jobs, local tax base. And as you all know, this is the way of our globalized world, where basically endeavors are not just within a border, but we do things to our highest and best capacity, and there is a lot of cross-border reliance. In the investment context, what ended up happening was that there was in particular a proliferation of international investment treaties. And these are treaties between two states and sometimes more states. And the two states promise that they will treat one another's investors in a certain way. In other words, the two states might promise we won't expropriate foreign investors without compensation, or we will treat foreign investors in a fair and equitable manner, or we will not discriminate against them on the basis of their foreign nationality. So they are really fairly high-pitched international obligations, and they are owed between the state. But the interesting thing these treaties did was it said, even though these are state-to-state obligations, we are going to give investors the right to bring a case, an arbitration, a conciliation, to enforce that where they think there has been some kind of a breach of the obligation. So it basically downloaded the ability to take a procedure against the state and got you out of the problem you had before, where you had to have the state step in and run the arbitration. And that was a huge step forward because obviously, first of all, it gave investors the ability to pursue something. But more important than that, it also made it very clear that these would be effective tools. And it was not just the right to enforce, but as much as anything, the fact of the right to enforce helped to make it clear that a state was committed to following the rule of law, that they had submitted themselves to the rule of law and to a process. And that feeds into increasing the positive climate for investment. So it really is part of a big ecosystem in terms of investment. You should know that the relevance of this not only was in the sort of 60s, etc., but in fact has been growing and is probably more relevant than ever today. And I know there are those who argue that investment arbitration, investment agreements are not really effective to bring foreign direct investment, and there have been a myriad of empirical studies. I can tell you that those empirical studies, by and large, support that this is an important tool in attracting foreign investment. And there are studies, for example, by OECD, UNCTAD, the World Bank itself. And what they have found is not only is this important to attracting investment, but almost as important as attracting investment is to having an investment, once it's come to your jurisdiction, expand, and even more important, stay. A lot of businesses, if they are finding that there are problems and political risk type issues like expropriation, may just leave. And that's the last thing the country wants after they have brought an investor into their country. An interesting statistic for you, just to give you an idea, a 2019 report by the World Bank said that every year, 1/4 of all investors investing in developing countries discontinue their FDI projects as a result of unresolved grievances with subnational or specialized regulatory agencies. So having an option to resolve a dispute is key to a positive investment climate. We also know that investor state is the primary tool for this, but I think it's important to know that we are expanding these tools and that mediation increasingly, conciliation, and even just regular negotiations are all a very important part. And so it's not just the actual ability to arbitrate and get a binding award. What's probably more important is prevention mechanisms and then early warning systems and ways to resolve problems and keep the investor in your jurisdiction. So knowing this whole life cycle, what we have seen, and you'll be very familiar with this, first of all, is a huge increase in the amount of cross-border investment in the last years. And that is, it looks almost like a ski hill. It just goes up immensely. And even though we all know there are periods where it goes up and down, the increase in investment in the last 30 years across borders has been immense and is critical. At the same time, the increase in the number of states signing these investment treaties, in other words, making promises about how they will treat foreign investors, has also gone up to the same level. So in the 1980s, we had about 400 of these. There are now about 3,500 of these kind of treaties. We know that over 200 countries in the world have at least one or more of these treaties. We know that at least 60 countries are negotiating or have recently negotiated model bilateral investment treaties. And I know that's an issue that Pakistan itself is seized of right now. And we know that over 90% of these treaties have ICSID and resort to ICSID as one of the possibilities for a breach of these treaties. So this is a world that is increasingly important and remains extremely important. As we've learned things through the case law, there have been some changing trends in these treaties. This is still a very new discipline. The first of these treaties, of course, was the one by Pakistan with Germany in 1959. And these early treaties were about 5 pages long. We have learned a lot, and they are negotiated and designed quite differently now. So they are now much longer and more detailed. They usually were just bilateral. Increasingly, we will see them with countries on a regional level. Originally, they were basically between a North country and a South country. We are seeing many more combinations now. We are also seeing investment chapters in full free trade agreements, so that they are really being brought overall into a country's economic relations with other countries. And we are seeing in many respects broader coverage, for example, protecting intellectual property rights where there is an investment, and those kind of new areas. In terms of the cases and the case law, I think this is something where there are just a huge number of stereotypes and urban legends. And so the one thing I would say to you is, if you are interested in this area, don't take the urban legends at face value, because there's a lot of misconception. A couple of the ones I wanted to address right now, probably the biggest one that we hear is that it is developing countries who are always on the receiving side of these cases. In fact, that is not true. Statistically, we know, in fact, that the countries who are more often the recipients of these cases are mid-level or transition economies. And I can tell you that the country that has had, among the countries that have had the most, you have Spain, Venezuela, Egypt, the Czech Republic, Peru, Libya, Poland, Canada, Croatia, India, and Russia. And in many cases, why have cases happened? You have to look more carefully into what's happened in the country. In the case of Argentina, there was one particular crisis where the peso was vastly devalued, and that created a number of cases. In the case of Canada, almost all of their cases have been under NAFTA. So the assumption or stereotype that it is always developed countries that have these cases is actually not correct from a factual perspective. The next stereotype is that claimants are always from developed countries. And I think it's fair to say that the most frequent profile of claimants will be from developed countries, in particular the United States, the Netherlands, and the United Kingdom, but that this is very much changing. And as you see treaties between different state partners, you are seeing the profile of who's a claimant and who's a respondent changing as well. One of the most important statistics, and one that people often get wrong, is the question of who wins and who loses. States win just slightly more than half the time in these cases. It's about 51-52%, obviously changes from year to year, but that statistic of slightly over half has been consistent for the entire period of investor-state dispute settlement. So states do not always lose. In fact, they win more often than they lose. The other one that I think is important is that about 35% of all of these cases resolve before you get to a final award. And what that tells me is that there is real room for mediation, resolution, for trying to settle the issue before you actually push it to a final decision. And a lot of people have come to that conclusion, which is why we are increasingly seeing mediation in this milieu. So that's a bit about what investor state is and the the type of litigation that we see here. The role of ICSID here is quite a special one. This was developed in the 1960s by a number of countries under the rubric of the World Bank. And it was developed to be, first and foremost, a facility or a place where you could arbitrate or conciliate. And secondly, to have a set of rules and a treaty specifically for this discipline. You should know that the specific obligations between states are not part of the ICSID Convention, and that has always been left to the states to tailor the way they want to with other states. What ICSID does have are a number of special features, and the first one is that it is so-called delocalized or self-contained, and that means that it is not attached to any domestic legal apparatus, but rather is completely separate so that you don't have the concerns about politicization of disputes, local biases, any of those things that can typically arise when you have a foreign investor and a host state in a grievance. We have this, of course, investor-state dispute settlement, where especially the investor may claim against the state. And you should also know that there are cases where, for example, a state entity can claim as an investor against another state, but usually it is the investor. The rules are drafted very much to create a balance between investors and states, and there is huge expertise within the ICSID Secretariat and a very effective cost structure. It is a non-profit institution, and they do hearings all over the world. So we do hearings, we have about 25 agreements with different hearing centers, and we have offices in 122 countries. So these are done in locations wherever parties would like to do this. What is probably the gold standard of the ICSID Convention, and what no other set of rules has, which is very critical to this whole link about enforcement and the ability to have an effective dispute settlement system, is that the ICSID Convention, the governing treaty, provides that awards are final and binding, subject to some very limited post-award remedies. So essentially what the state delegates said was, we would like to have this system. We want it to be a fair, neutral, impartial system, but we also want it to be an effective one so that once there's a result, there will be the ability to review, but on limited grounds, and otherwise we want to encourage basically going forward and making sure essentially that there is a concrete known result. So the ICSID Convention provided that there would be a very limited remedy known as annulment, and member states agree that they will recognize monetary awards after they have gone through the annulment process, or if that's not initiated, in accordance with the final award. And the monetary award is enforceable as if it is a final judgment in any contracting state. So what that means on a very pragmatic basis is the successful investor, or for example, state-owned entity, takes their award and can enforce it in any of the 157 ICSID member states. So that makes it extremely effective, and I would say probably one of the reasons why ICSID is the premier institution. The other important thing that I want to note is that ICSID has always been a leader in terms of evolving investor state and modernizing. And we have just been through a 5.5-year process where our rules were updated, and there are a number of new features that relate to concerns that people have had in the public dialogue about investor state. So to give you an idea of some of these, parties now have to declare if they have third-party funding. There is increased transparency of the process. There's an expedited arbitration process, and most important, there's a standalone mediation. Now, I'd like to just come to a quick end to this because I'd like to hear from our other colleagues and get back to Ellen. So I just want to say 2 final words. Number one is this is all part of a system, and what states and investors as well need to recognize is that to make this system effective, what's really important are having complementary dispute prevention. And that means governments need to understand what their obligations are the importance of capacity building, the importance of treaty design, and the importance of early warning systems. Fix the problem before it becomes litigation. The final thing I wanted to note here is in terms of dispute management. If the problem has not been resolved early, it's very important to manage your dispute very professionally. And I'll simply refer you, we have something called Guidelines for Respondent States on our website, and it's got a lot of hints for governments about how to pull together a council team and what to expect in the process. So that is a very broad range of items, and I'm very happy to answer any questions, but I'd like to pass it back to Ellen and to my colleagues on the panel. Thank you.
Meg, thank you so much for that comprehensive but very concise discussion about ICSID and the role of investor state settlement disputes. It's been very interesting. I also was very pleased to hear about some of the recent developments that you've been initiating at ICSID, and also very fascinating to learn about the ways in which mediation in particular is being incorporated at this time, as well as the new rules. So I encourage everyone who's interested and who would like to learn more, there's a wealth of resources and information on the ICSID website. And if you have questions, we can certainly take them when we move to the end of this panel. Meg, thank you so much for joining us. It's really been such a privilege to have you here. Unfortunately, Judge Danny was not able to stay on because of technical difficulties, so we're going to move to my dear colleague, Howard Herman, who you heard. Howard was the ADR director of the Northern District Court in Northern California. He's also a panelist here at JAMS, a mediator and an arbitrator. I've had the pleasure of working with Howard over the years on the Weinstein-JAMS Fellowship Program, and I will be able to speak a little bit more about that if we have time. But for now, I'm going to bring it over to Howard. Howard, please tell us a little bit about your background and the work that you've done in connection with the courts. And you'll need to unmute so we can, and we need to test to make sure that we can hear you. There we go.
Can I be heard? Is this all right?
I can hear you. Go ahead.
Okay, excellent. Well, thank you very much, Ellen. And I'm so pleased to have been invited to speak with you all today about the experiences that we've had in the U.S., particularly in Northern California, in terms of the role that the court has played in the institutionalization of ADR, and to share with you some of our experiences in what we think has made the program a successful one over the years. As Ellen mentioned, I spent more than 20 years, up until about 2.5 years ago, as the leader of the federal trial court's ADR program in Northern California. I've also been involved in a couple of other court-annexed ADR programs in building them. So I'm going to share with you mostly the experiences in the federal court in Northern California, some of the elements that I believe went into making a successful program over time. The place where I usually begin is with the idea that it has taken many years to build a full, complete program. It's not something that happened overnight for us. Our journey into court-annexed ADR in the federal court actually began about 45 years ago with a visionary chief judge of our court who was very interested in trying to make the court a more accessible place for the litigants. And it really wasn't driven by just a desire to process cases through the system, but really on a focus of trying to make justice more accessible for the parties themselves. And that has been the guiding motivation over time. Now, certainly that does mean not having backlogs of cases. It means resolving things, but it's not just about resolving them. It's about resolving them in a way that the parties feel they have had a real experience of justice. So we began 45 years ago in an experiment with non-binding arbitration systems, and that was in the late 1970s. That moved forward into experiments in the 1980s with neutral case evaluations done by legal experts. And that moved then in the early 1990s into the program that really is the program that that has been in place ever since. A system, I think, that bears some resemblance to some of the efforts that are going on in Pakistan to build a multi-option system with different processes available to the litigants for different sorts of disputes. The idea was to fit the forum to the fuss, to try to direct cases to mediation when mediation is most appropriate, to neutral case evaluation, or to arbitration, and for the court to work in tandem with the private sector in order to provide litigants with an array of options to try to get their disputes resolved fairly, efficiently, and equitably. So I'm going to focus most on how the court proceeded to establish its multi-option system, and the elements of that system that I think helped us to successfully institutionalize ADR as a component of our legal system. The first point has really been a true commitment by the court to the idea of ADR. And for us, that meant that it has actually been encoded in the rules of the court. There's a formal statement of the policy of the court being to assist the parties involved in civil litigation to resolve their disputes in a just, timely, and cost-effective manner, as a formal statement of policy. In other words, that the job of the court isn't just to adjudicate the cases, but it has a broader mission, as I've just expressed. And then the court goes on to say that in order to do that, the court has created its own internal programs, and those are the programs that I was responsible for more than 2 decades, and that alongside of the court's own internal programs, the court encourages the use of programs outside the court that are operated by private entities, like JAMS and other institutions. And then establishes sort of what the court's allowed to do, which is on its own initiative or at the request of the parties to actually refer the cases out either to the court's internal processes for alternative dispute resolution or out to other private entities or individuals who would provide the mediation or arbitration or whatever the appropriate ADR service might be. That comes alongside as a practical matter and as a matter of our rules with a presumption that using some kind of ADR mechanism is probably the best approach for most cases. That most civil litigation can be more productively and more satisfyingly for the parties resolved through a mediation or a conciliation or an arbitration process than it likely will be by going through the court process. And so on the one hand, the court established a set of rules, a set of procedures, and I've seen that you certainly have some of those same sorts of sets of rules and procedures in writing in Pakistan. But at least as important as the formal rules has been the development of actual practice by the court, by the judges, of encouraging the parties when they come to their court and actually using the systems. And And that takes the form in our system of a conversation of one sort or another between the court and the lawyers at the first opportunity, at the first case management event that occurs in the case, for the court to consider with the lawyers, well, what kind of ADR is going to be most appropriate? And the actual activity of engaging the lawyers and the judges in that sort of conversation. And it's a conversation that takes place in part in writing through the questionnaires that the lawyers turn into the court, that there are case management statements in advance of the conference. But in fact, in practice, actually occurs as a matter of real dialogue between the judges and the lawyers in court about whether any particular case would benefit from a referral either to an internal court process or to an external court process. And I should note that one of the reasons that in our courts we ensure that there are internal court mechanisms has to do with the finances that are involved, because our courts at least come at this with the approach that it's important that if parties are going to use an outside provider that costs money, the parties have to have the resources to do that, and that not all cases and not all parties do have those resources. So the court established its own internal systems, which can certainly provide service for those cases where the case wouldn't support the hiring of an outside mediator or arbitrator and the payment for those services by the parties. So in our system, the lawyers are in dialogue with the court. They are permitted to choose their own providers if they want to, but in the final analysis, the court has the ability to simply direct that the parties should go to some kind of ADR as the court deems appropriate. So over time, over the last, since the court instituted the multi-option system, which is probably, I guess at this point it's 25 years or so ago, the need for the court to order things has diminished, because as people become more accustomed, more satisfied, and a culture develops among the lawyers and the parties themselves and the businesses in particular, the repeat users of the court system, it becomes less and less necessary for the court to issue orders requiring things, because the parties themselves have learned the value of these alternative systems. But that's something that grows slowly and builds over time. So the first, I guess, in some ways, my first point is to counsel a bit of patience as these things develop, and also to think about the ways that you can begin small and grow the program piece by piece as folks become more and more comfortable. So let me say that, for example, when we first began with the multi-option system, it wasn't fully court-wide. It wasn't in every courtroom. We started with a few judges who were signed on to what was put together as a pilot program, and then it moved to the whole court. So again, your own systems, what works in one place doesn't necessarily work in another, but the idea was to begin slowly and to build success upon success, and that was a really important component of our institutionalization of the program. Another key component had to do with education of the bar, education of the public, and education of the judges. So let me take apart those different elements. Education of the bar really has a couple of important components. In our system, we instituted at the beginning a requirement that was actually quite controversial among the lawyers at the start. The court set out an informational booklet about all the different sorts of ADR that were offered, what the advantages and disadvantages of arbitration might be as opposed to mediation, as opposed to a neutral evaluation. In your case, that might include conciliation. And actually mandated that every lawyer and client in every civil case read the short informational booklet and actually file a certification with the court that they had read it. Not that they actually would do it, but just that they had to verify that they had actually educated themselves about these new systems. And at first, the bar was somewhat resistant to this. They thought that this was an interference in the lawyer-client relationship, but they got past that, and it actually over time had a big impact because people did have to engage. There was a push for everybody to engage in conversation about this and to learn to have discussions. And in some ways, it took the burden off the lawyers because the lawyer would say to the client, I have to talk, the court requires me to have this conversation with you. So even if the lawyer was resistant to having that conversation, it was just something that they had to go through. So again, in our system, that's one piece of what helped to make things work. Another component isn't directly provided by the court, but it's about the role of the law schools. One of the things that I've always done alongside my work at the court, and I continue to do it alongside my work at JAMS, is to teach these skills to law students, to ensure that the new lawyers, as they're being trained, are taught about the fact that cases don't just get decided in court. Most cases, many cases are about being negotiated to resolution. So lawyers need to be taught negotiation skills. They need to be taught about the mediation process. It needs to become an element of the law school curriculum in order to promote the institutionalization of these processes throughout the legal culture. So again, not directly required by our court system, but an important component of the institutionalization of these processes is for this to be promulgated within the law schools, because that helps to bring the bar along. Second point has to do with outreach to the public, to ensure that that there are some kind of programs or informational exercises provided to the public by way of programs or requirements like this booklet, where the lawyers are working with the clients themselves. And it's not just the lawyer that needs to read the book. The lawyer's saying, I've gone through it with my client. So the clients themselves are being educated. And in our system, we found that actually many of the corporate leaders, once they start to see the value of these, they see that their cases are actually being resolved more effectively and more efficiently. Part of the change in the legal culture comes from the in-house lawyers and from the business people demanding of their counsel that they adopt better mechanisms for getting their cases resolved more quickly and more effectively and less expensively. So making sure that there is an outreach going to the business community and to particularly to the other repeat users, has been a key piece. And then finally, there's the question in terms of education of working with the judges themselves. So once there are a few judges who were signed on to the idea and began to understand the value of these processes, it's about judges teaching other judges about these systems and helping the judges to teach the judges or to spread the word among the judicial officers about how best to direct cases, how to manage your caseloads, how to identify a case where, for example, where the parties are in continuing relationship, and that might suggest to you that that's a particularly good case to send to mediation, because it's not a one-shot deal. And there may be reasons why mediation would be the most effective way to resolve the cases. So making sure that the judges themselves have enough information to be in an effective conversation with the lawyers and the parties about how best to resolve their dispute. So the last element I want to focus on has to do with the administration of these programs, and what really is, I think, actually the most important thing, and that is the quality of the actual neutrals themselves, the people who are serving as the mediators, as the arbitrators, as the conciliators and evaluators. Because at the end of the day, everything about the program depends on the actual event that's being hosted by the neutral, and the neutral's ability to conduct an event that is going to feel like it is delivering justice to the parties, that it is a fair process, that it is a process that has real integrity to it, where the parties and their lawyers feel like they have had an appropriate opportunity truly to be heard. So that means that institutionally, a big part of what we did at the court and what any institution that is providing these services needs to do is to ensure that they have truly high quality neutrals engaged. That means a real focus on the training requirements for the neutrals, and it means ongoing supervision of what's happening, so that somebody is responsible for really surveying the participants and what their experience is after the fact, collecting that data, observing now and again. And certainly in our setting, one of the ways that we did this is by ensuring that there were continuing gatherings of myself and the other staff, the trained staff of mediators with the court, to review cases with the people who were serving on the panel, to make sure that we actually would go through and dissect what happened in the cases, and have practice groups where folks could really learn from each other about what makes a good mediation, and ensuring that there are continuing education requirements, not just basic education requirements, so that oversight at the end of the day is what is going to ensure that people are drawn to the program, because what they're having is a truly high quality experience once they arrive. One last thought about the recruitment of neutrals to a program as well. One of the things that Chief Judge Peckham, our sort of founder of the program, did when he was first getting started is he tried to recruit some of the most high-powered members of the bar, of the legal community that we sat in, to get them to be trained as neutrals, so that they could see the values, they could learn it directly, and they could spread the word among the legal community. So it was a particularly effective tool to try to draw in the leading members of the bar and help bring them on board with the ADR project. So I'll stop there. I realize I've gone on a bit and turn things back to Ellen. Again, as with Meg, I'm certainly willing to take questions if there's time.
Howard, thank you so much for that. I know that everyone who's been in the room has been there for a long time. You have been participating in a conference all day, and it's the evening there. So we understand that listening to those of us who are coming to you via the technology may not be the easiest. I think that you all who are participating in this conference are no doubt the key audience to respond to some of the points that have been made both by Meg and also by Howard here in terms of the importance of educating the bar, educating lawyers, education of judges, outreach to the public, establishment of institutions, all of which you are involved in the development of dispute resolution, conflict prevention, and management in your country. I know we don't have too much time, and I'm sorry that Judge Danny lost his connection. Judge Danny Weinstein wanted me to let you all know that he fervently supports your efforts. As you heard, he has been a pioneer in the development of mediation and dispute resolution around the world, and we are so pleased to be able to support this conference. So if there aren't any questions, and I'll just wait a moment to see if there are, but if there are not, I will pass this back to Mr. Hamid Sharif, who I understand will be closing at least today's conference. And we'll look forward to hearing more about the developments that you are all working on in Pakistan. And we wish you also a most wonderful conference tomorrow as you continue your discussions about the various ways in which your institutions and stakeholders and champions can collaborate to develop amicable dispute resolution mechanisms in your country. So, any questions? If not, Mr. Hamid Sharif, please.
My mic. Hello. Yes, we do have a couple of questions.
Very
Justice
good.
Ijaz, can you please get the mic to Justice Ijaz? Mic over there. The hand mic, please. Can you please get that operational?
We'll do our best to hear. You may need, Mr. Sharif, you may need to repeat the question for us if our audio is not sufficient, just so you know.
Hello.
Hello.
Judge Howard, was this initiative that was taken, I think, in early 70s, was that judiciary took it or through legislation, or it was internal judicial initiative?
So the original initiative was really a combination of judicial initiative not exactly legislation. In our system, the judiciary is less dependent, I would say, than most places in the world on a specific legislation in order to make internal changes. Under the broad authorization of its judicial authority in the 1970s, the court was permitted to look at the potential that arbitration would have, and there was an authorization for courts to experiment with this. And then our judicial, as I understand it, this is actually before my personal involvement. The Judicial Conference of the United States looked for some courts that were interested in volunteering to participate in the experiments. And our court was one of a handful of courts that basically said, yes, we're interested. So there was judicial initiative in pushing this forward, but it was not, it came more from the judiciary than from the legislature.
Thanks, Howard. We have one more question. Justice Ijaz, please.
Mr. Herman, thank you for a very good, I would say, excellent overview of what you have achieved in the last 45 years. In your talk, I can say that we see several parallels that we at Islamabad High Court wish to achieve and hope to achieve with the support of ICADRP and other organizations such as them. I wanted to ask you if you could tell us something about the regulation of the mediation profession as it is. How is it regulated, and have you the lessons that you've learned over time in regulating them? Thank you.
This is a very important question and a difficult one, because so let me say that I think that the U.S. has actually not done a very good job in this respect. We have in the United States quite a patchwork of regulation of mediators. There is no national certification or regulation, and it varies from state to state throughout the United States. Each state has different requirements, and some states have no real requirements at all. In the state of California, where I live and work, any individual, there's no law that prohibits any individual from just holding himself out as a mediator with no training, no experience, nothing. So what that means is that the institutions like the court need to come up with their own sets of requirements and certification processes, which substitute for any specific regulation of the profession of mediation. So our court, by rules of court, established a set of guidelines, a set of requirements to serve on the mediation panel. They include a certain number of years of service as a lawyer, or if you're not a lawyer but a mediator, we have a requirement that you be at least 7 years in law or another profession if you're going to be a non-lawyer mediator to serve. And we also have a requirement that in our court, there is an internal training that everyone has to take. There's a rigorous application process. But I think that there are certainly clearer requirements in many other places in the world that set out in a frankly a more professional way the rules for who gets to be a mediator and who does not.
Thank you.
Thank you, Howard.
Yeah.
I have one question to Meg, if Meg is still online.
Yes, Meg is.
Okay, Meg, I wonder if time has come not for an ICSID, but an ICPID. And what I mean by that is maybe we need an international center for prevention of international disputes, because the World Bank, of which you're the vice president, along with other MDBs, have very successfully opened up other countries for investment through policy lending. And yet what we see is we don't see the capacity on the other side to negotiate these very complicated contracts, which then land these countries in extreme difficulty and often before ICSID. And they think there's a perception. I know Nusrat has written a whole thesis to say this is not true, but there's a perception that the developing countries get the raw end of the stick. And I just wonder if the time has now come to really pay attention to building the capacity of developing countries to enter into these complicated public-private partnerships and, independent power projects. Because frankly, in the case of Pakistan, if you're following Pakistan on the economic front, Pakistan is on the verge of bankruptcy primarily due to the IPPs, which were badly negotiated and continue to be badly negotiated because we don't seem to have the capacity to actually negotiate them well. And any comment on that, Meg? Thanks.
Certainly agree with you 100% that a focus on prevention is a piece of this puzzle and needs a lot of work. The World Bank has been doing more on that, and in particular has developed basically a prevention mechanism or early warning mechanism. It's called the SIRM, SIRM, and they have piloted it in about 10 or 15 countries. So I think that is a part of the puzzle and certainly one that we very much support. And I agree, helping to develop the capacity to negotiate these complicated contracts is very, very important for sure. In terms of ICSID, I think part of our effectiveness is being impartial and specialized. So I don't know that ICSID would be the right place to go and help negotiate a public-private partnership, but obviously enhanced capacity in that area is always very welcome.
Thank you, Meg, and we'll stop this session here. I know that we may have more questions, but I think all good things have to come to an end. And I want to take this opportunity to really thank our panelists who are in a different time zone. I know some of you got up early to be able to join us, so I want to really express our appreciation. And Ellen, please pass on our thanks to Danny Weinstein. We're very sorry that he couldn't address us. We were very impressed with his credential, and I hope that on another occasion we will be able to have him speak to us. With that, may I ask the audience to show our appreciation for the panelists. Thank you.
Thank you so much.
Okay, we're now at the end, and I'm supposed to deliver some closing remarks. I have absolutely no intention to try to cover what has gone on during the day, except to say that I hope that the session today, the proceedings today have underlined to all of us that ADR is a way forward for a country like us. In fact, we're decades behind, I believe. I think we should have moved on this much earlier. It's not a question that there's a failure of the judicial system. I think, while our judicial system has problems, I think as a culture, as a nation, we have a rich heritage on which to draw upon. And using that heritage, there is absolutely no reason why we should not go back to some of the traditional methods of dispute resolution and bring them to the fore. There's a very interesting study which someone tells me about how during the colonial times, many of our systems were, of course, changed. And a very fascinating one is there's an Indian author who's written a whole thing about this rasagiri. That rasagiri, stealing another person's animal was actually kind of a legitimate, okay thing to do because it settled an issue. And when you criminalize that, you actually then opened up a whole can of worms with which we are still stuck. So I think we need to have some indigenous research, indigenous thinking on what are the appropriate dispute resolution mechanisms to which we can turn to provide speedy justice to ordinary litigants. I think I was fascinated by the presentation from KP by Quresh Khan Saab. And frankly, I think we need to learn a lot from that experience, because it seems to have been going on for a while. There are different things at play there. What is it that we can learn from there? And I think that sort of research, I hope the Law and Justice Commission, they have an adequate fund for that. Under the Access to Justice program, we established a very handsome fund for them, which is still largely untapped. And that was supposed to be used for this sort of research. And I hope that can be tapped into and we can really come up with practical ideas. On the more immediate, I think coming back to Islamabad, it is very heartening to see that we have at the highest level with the Chief Justice and his colleagues in the High Court, Justice Ijaz, who's with us, and Justice Aurangzeb, who was here earlier, that we do really have leadership. And I hope that that leadership can be converted into results on the ground, working with the lawyers and working with the district and session courts, so that we're able to deliver something. And the legal framework, fortunately, with some of the imperfections with Justice Ijaz pointed out, with which I wholly agree. I think the question on regulation of ADR was a good one, but I think in our case we may have regulated too much. But that's something we can still work with. But I think given that we have a legal framework, given that we have the leadership in the High Court, I certainly would wish, and I hope that very quickly Islamabad can be the place in Pakistan where we can demonstrate that ADR can work and that ADR can make a real difference. So with that, let me thank all of you, and let's remind you that tomorrow, those of you who have registered, we're continuing at the Islamabad High Court. Again, the High Court is showing leadership by actually inviting us in and allowing us to use their venue for the training tomorrow. But very lastly, before we close up, I have a request for Justice Ijaz Saab to please come and make a presentation of a bouquet of flowers to show our appreciation to Dr. Piracha for all the tremendous work I know she has been doing for the last weeks, to the point that, I think we have to restrain her to say, look, slow down. I mean, she was here this morning, 4 a.m., trying to check this hall out. So that's the sort of crazy things she has been up to. And, we really want to appreciate our colleague on this. So we just have a small token of appreciation, which I hope someone's going to bring me, Farooq. Right? And I'd like Justice Saab to present that to Nudrat. Yes, we're just waiting a second for the flowers.
Really enjoyed hearing Howard Herman. It was just like a script that I have in my mind. It's exactly just unfolded over 4.5 decades there.
Yeah, we've been talking about it for so long. Oh.
With his shield.
We're actually presenting a shield to Justice Ijaz Saab as well, and all the panelists, you have your shields, which we'll get to you. With a big hand for Dr. Thank you. Ehsan Sadiq Saab, please join us. And Dr. Quresh Khan Saab, please. And Nudra, please come forward. We have a token of appreciation for you. A big hand, please.
Thank you so much.
With that, let me thank you all again and invite you to join us for dinner.